Hello. This lecture is for ISOL 633 at the University of the Cumberlands. The textbook is the Legal Issues in Information Security. This is for Chapter 6, Security and Privacy of Health Information. Health information can be used in a number of different ways. Doctors and other healthcare professionals use and share it to provide medical care. Insurance companies and employers share it for insurance coverage and payment. Many people worry that this type of information could be used improperly as well as for valid uses. Insurance companies could use it to deny healthcare coverage. Employers could use it to decide not to hire someone. Thieves could steal medical information and use it to commit medical identity theft. Healthcare providers no longer store health information just in paper files. Many providers use computer systems to create and store electronic health records. When information is stored electronically, data may be combined from a number of different sources. It's possible to create comprehensive medical records that contain a lot of data about a person. Healthcare industry must take steps to secure these types of records. In this chapter, we'll focus on laws that protect privacy and security for health information. For the most part of this chapter focuses on the unique challenges presented by growing amounts of electronic health information. The chapter also discusses how federal and state laws work together to protect this information. So the learning objective for this chapter is to describe the main parts of the Health Information Portability and Accountability Act, or HIPAA, and how it protects health care information. Topics covered include what the business challenges faced the healthcare industry are, why healthcare information is sensitive, what the Health Insurance Portability and Accountability, or HIPAA Act is, what the role of state law in protecting medical records is. So key concepts we'll look at are the healthcare industry and information privacy. We'll look at the HIPAA Act. We'll look at state laws regarding confidentiality and privacy of records and why healthcare information is sensitive. We'll also describe the business challenges faced in healthcare industry and explain the main parts of the HIPAA Act. And again, we'll look at the role of state law in protecting confidentiality and medical records. So business challenges facing the healthcare industry. Healthcare industry faces many of the same privacy and security challenges as other industries. The difference is the type of data that is used. The healthcare industry collects consumer financial and personal health information. Healthcare providers collect consumer financial information to make sure that consumers pay for medical goods and services. They collect health information to provide these goods and services. Many people consider health information to be very sensitive. Healthcare industry often collects and stores this data in electronic form. Collects from a number of sources. Hospital computer systems contain notes from hospital employees and primary care physicians. Health insurance companies collect and combine patient data from different providers. It's important for organizations to maintain the security of computer systems that hold health data. Patients demand that this data be protected. Unfortunately, health information often is compromised in data breaches. This can cause problems for health care consumers. Health information can be exploited and used improperly. One such crime is medical identity theft. Medical identity theft is a specialized type of identity theft. In medical identity theft, thieves steal a person's name and other parts of his or her medical identity, using their information to get medical services or goods. When the thief gets health care, providers can add treatment notes from the thief on the victim's medical record. The thief can use personal information obtained from health records to steal health insurance information and make a false claim for health care services. Unpaid medical charges could end up on the victim's credit report. So why healthcare information is sensitive? Most people consider their medical information to be among the most sensitive types of medical information, of personal information. It's because the information can be of full private details that people don't want to share. People must share these details with healthcare providers to receive treatment. Providers include this information in medical records. These records contain information on diagnoses, lab results, and treatment options. And they also contain information about chronic conditions or mental health counseling. They also hold private details about a person's lifestyle. Doctor-patient confidentiality is a long-held tradition. The Hippocratic Oath, which dates back to the 4th century BCE, recognizes this belief. Hippocratic Oath is a pledge that many medical school students recite upon their graduation. Traditional version of the oath states, "Whatever I see or hear in the lives of my patients, whether in connection with my professional practice or not, which ought not to be spoken of aside, I will keep secret, or considering all such things to be private." The statement means that a doctor will keep the patient's health secrets. Health records often contain intimate details about a person. People fear that they can be embarrassed if the health information isn't kept secret. Some people may even fear for their lives if particular intimate facts such as person's reasons for health counseling are disclosed. People fear that others may discriminate against them. They fear that insurance companies or employers could reject them because of information in their health records. For instance, people who have been treated for anxiety or high blood pressure in the past might fear that their application for private life insurance will be denied. People with a known genetic predisposition for certain types of diseases might fear that they will be denied health insurance. The Health Insurance Portability and Accountability Act of 1996, also known as HIPAA. Congress passed the HIPAA, or Health Insurance Portability and Accountability Act, in 1996. It created the law to help make health insurance portable. HIPAA is used to fight health insurance fraud and eliminate waste. It also simplifies how health insurance is administered. HIPAA is best known for its rules to protect the privacy and security of personally identifiable health information. These terms are part of the law's administrative simplification requirements. While these rules are the focus of this chapter, it's important that you know that HIPAA has other provisions as well. They were enacted so that health insurance could be portable or carried from one employer to another. Prior to HIPAA, some workers felt that they were stuck in a job because they feared they would lose their health insurance if they changed jobs. HIPAA protects health care coverage when workers change jobs. It protects both workers and their families. It forbids a new employer's health plan from denying coverage for some reasons. It prohibits employers from discriminating against workers based on certain conditions such as pregnancy. Also limits employer-provided health plans from using pre-existing conditions as reason for excluding workers from the plan. So again, the purpose of the HIPAA Privacy Act is to allow consumers to control the use of the health insurance, to improve health care in the U.S. by restoring consumer trust in the healthcare system, and to create a national framework for health privacy protection. So the HIPAA security rule requirements and the covered entities. Covered entity has administrative duties under the privacy rule. Must designate a privacy officer. This official is responsible for developing a covered entity's privacy policies and securities. This allows the covered entity to scope its privacy policies and programs to its size and structure. Allows covered entities some discretion when they create their programs. Covered entities that are large with complex structures must develop policies appropriate for the structure. Small entities are not held in the same standard. The covered entity must also designate a person to receive consumer privacy complaints. This person handles complaints about the entity's own privacy policies. They also handle consumer complaints about privacy rule. The person also answers questions about the entity's privacy notice. Privacy official often serves as this contact person. Covered entities must create policies and procedures to protect the privacy of all. Policies that protect the privacy of protected health information include destroying it properly. They can also include requirements that paper medical charts be secured in locked file cabinets. This requirement is similar to HIPAA security rule. However, the security rule applies only to electronic protected health information. Covered entities must train their employees on the rules and its privacy policies and procedures. Must train all employees, even part-time employees, volunteers, and interns. The covered entity also must have a disciplinary policy for workers who violate the privacy rule. This is called a sanctions policy. In February 2009, Congress passed the Health Information Technology for Economic and Clinical Health Act, or also called HITECH, H-I-T-E-C-H Act. The HITECH Act is part of the American Recovery and Reinvestment Act of 2009. With a $787 billion stimulus package. President Obama signed into law in 2009. It contains incentives that encourage the adoption of healthcare information technologies. It anticipates an increase in the use and exchange of electronic protected health information. Because of this, the HITECH Act strengthens HIPAA privacy and security protection for personal health information. The Privacy Act requires covered entities, including business associates, to mitigate and authorize use or disclosure of protected health information. Prior to the HITECH Act, a covered entity didn't have to notify individuals that their protected health information was used or disclosed in an unauthorized manner. HITECH Act now requires them to do so. It creates notification requirements that cover entities must follow in the event of a breach of unsecured protected health information. Both covered entities and business associates must follow these rules. A breach is any impermissible use or disclosure of unsecured protected health information that compromises the security or privacy of the information. Any unauthorized use or disclosure is presumed to be a breach under the law. In some cases, a covered entity must be able to show that there is a low probability that the protected health information was compromised. If they can do that, then the breach notification requirements do not apply. To show that there is a low probability that protected health information has been compromised, a covered entity must engage in the risk assessment. To conduct the risk assessment, a covered entity must review the protected health information that was involved in the breach. Is the information involved very sensitive? Is it more likely to lead to identity theft? who used or received the information? Does the entity know who's used that information? Was it an impermissible use or disclosure? Was the protected health information actually acquired? Was it involved actually viewed? Was there a download or by an unauthorized individual? And have risks been mitigated? If the entity knows who used the protected health information, can they get assurances that they will not disclose or use the data further? Can the entity ensure that the protected health information has been destroyed? So HIPAA privacy and security rules. So HHS published the security rule in February 2003. This information security rule requires covered entities to use security safeguards. These safeguards must protect the confidentiality, integrity, and availability of electronic protected health information, or EPHI. EPHI is patient health information that is computer-based. Covered entities were required to comply with the rule in 2005. Like the Privacy Act, the Security Rule was the first time the U.S. government stated federal protection for electronic protected health information. Under the rule, covered entities must protect their electronic protected health information that they create, receive, maintain, or transmit. They must protect it from reasonable anticipated threats. They also must guard against use or disclosure of that information that aren't allowed by privacy rules. Covered entities must create policies and procedures to comply with the security rule. They must review these documents on a regular basis and update them as needed. They must provide training to their employees. They also must make security program documents available to employees in printed manuals or on websites. A covered entity also must have a sanctions policy to discipline workers who violate the security rules. Security rule allows covered entities flexibility to create their overall security programs. Rule doesn't require covered entities to use specific types of technologies to create their program. Covered entities must think about the size and complexity of the entity, its technical infrastructure, hardware and software security resources, the cost of security measures, and the potential risks to electronic protected health information. So, role of state laws protecting health records. HIPAA sets the floor for information, personally health information, and private protection. It means that states are free to create laws and rules that provide more protection than HIPAA. Covered entities have to comply with both laws. Generally speaking, the controlling law is whatever law is stricter or provides greater patient rights. Any state law that is contrary to HIPAA isn't allowed. State law is contrary if it's impossible for the covered entity to comply with both the state law and HIPAA. In these situations, the state laws are preempted by HIPAA. They are not allowed. States enact many laws that may affect personal health information. These laws can provide more rights than allowed by HIPAA. For instance, in 2008, California enacted some of the strictest patient privacy protection in the country. California's laws specifically specify harsh penalties for providers caught snooping in patient medical records. California healthcare providers must report privacy breaches more quickly than is specified in HIPAA. California law requires healthcare providers to notify people within 5 days of a breach of patients' medical information. Also gives people the right to sue their healthcare providers for violating the law. It's important to review both state law and federal law when reviewing questions about the security and privacy of personal health information. Let's review both types of laws to make sure that covered entities are appropriately protecting this information. So in summary, personal health information is one of the most sensitive types of confidential information. Personal health information is no longer limited to paper files. This type of information is often stored in electronic form. No matter what form it's in, this information must be protected. Healthcare providers must take steps to ensure its privacy and security. They are required to do so by both federal and state laws. They face fines and other penalties for failing to protect this information. Thank you.